I bought the ranch to get away from people like her, 60 acres of fenced land. A gravel drive half a mile long and not a neighbor in sight, or so I thought, turns out. I had one. She introduced herself with a printed letter from the Homeowners Association. Informing me that my mailbox was not Regulation Brown, I politely informed her. I wasn't part of the HOA. My land sat well outside their jurisdiction. She didn't like that. That's when I learned her name was Karen, and she was the HOA president. Next few weeks, I noticed odd things, footprints on the gravel where no one should be walking, fresh tire tracks near the south gate once. I spotted her taking photos of my barn with her phone. I confronted her one morning after catching her parked. Halfway up my drive, I was just turning around. She said, sipping coffee from a stainless steel mug, "You have such a lovely property. I sometimes show it to guests." She smiled like it was a compliment the next day. I installed a gate with a coded lock. My land, my rules. The county had no objections. The road was on my deed. No easement, no shared access. That's when the real campaign began, Karen emailed. Then she called. Then came a letter on behalf of the HOA stating I was blocking traditional community access. She said I was creating tension in the neighborhood and accused me of being hostile to shared values, and then she sued me, not the HOA. She personally filed a civil complaint claiming I had illegally restricted shared rural access, historically used by surrounding homeowners. According to her, she had a right of usage based on the previous owner's verbal agreement, what she didn't know. I'm a retired civil attorney, 32 years in practice, 12 of them in property and land use law. So I brought property records, satellite maps, a signed letter from the previous owner, and trail cam footage showing her entering my property without permission on 6 separate occasions. 2 of them, while escorting guests in court, she arrived with a binder of speech and enough arrogance to fill a stadium. She talked about community heritage and how I was damaging neighborhood harmony. She even tried to frame herself as a representative of public interest. The judge wasn't impressed. After I presented my documents, he asked her one question. "Do you have any legal right to access the property?" she said. It was understood tradition. The judge gave a tired sigh and dismissed the case on the spot, but then, and here's the sweet part, he turned back to me and said, "You're welcome to file a counterclaim. In fact, I'd recommend it." I nodded. 2 weeks later, Karen, HOA president or not, received a court order, $11. 0 in trespassing fines, $2,500 for legal fees. A formal injunction prohibiting her from setting foot past my fence line. Since then, the gate's been quiet. No more visitors, no more passive-aggressive emails, just the wind, the hills, and the sound of show. Someone finally learning what no means. She may run the HOA, but she no longer runs anywhere near my ranch.